Can I just pay for the stuff? I was trying to find my wife's debit card.
You took property that does not belong to you and exited a store. I get it, it sucks, but it is what it is. Mr. Powers, listen to me right now, okay?
Yeah.
This is gonna be the one and only time I'm gonna tell you this. All right? At this point, we can't figure out who you are. They have nobody can figure out who you are.
I'll just leave the property.
Us or them. No, that's not happening at this point, okay? You're detained. At this point, you're under arrest for shoplifting, and you're gonna be going to jail. Yes, sir. Seriously. All right? So,
Yep.
like I said, grab a seat. Let's type things out and go from there. And we have no ID or anything in your bag, right?
This is ridiculous.
That's fine. Like I said, no ID or nothing in your bag. That's fine, you can do that. But to answer my question, do you have any ID or anything? Nothing. Nothing with a name on it, nothing like that.
No.
All right.
My luggage ticket.
All right. Where did you came on a Greyhound when you came to Orlando?
Yes.
From where, Michigan?
No, Florida. Miami.
Oh, from Miami up to Orlando. Yeah. Okay. All right. Well, like I said, that's where we are, okay? So I need you to just bear with me, and it is what it is at this point, okay?
Can I just pay for the stuff? I was trying to find my wife's debit card.
That apparently it's past that point, okay?
Why? What did I do?
You took property that does not belong to you and exited a store, or attempted to.
This is ridiculous.
Okay? So I get it, it sucks, but it is what it is.
On April 20th, 2021, Orlando Police Department responded to a shoplifting call at Universal Studios, Florida. What made this arrest legally significant was not the theft itself, but the constitutional exchange that followed. Under Florida Statute Section 812.015, retail theft is complete the moment merchandise leaves merchant control without payment. The suspect's offer to pay after the fact carries no legal weight. The offense was already committed under Florida law.
I will not answer any more questions. You have not run me my rights. I will file a lawsuit on illegal detention.
Okay, that's fine.
For my attorney.
That's fine. I don't have to read you your rights.
You do if you're detaining me.
No, I do if I'm questioning you, and that I am not.
If I'm not under detention, I wish to leave.
You are detained and you are not free to
Then
leave.
why didn't you read me my rights?
Because I'm not questioning you about the crime that you committed.
Well, then you can't detain me.
I can.
The suspect then invoked what he believed were his Miranda rights, claiming the officer was required to read those rights before detaining him. This reflects one of the most common misunderstandings in American criminal law. Miranda warnings are not triggered by arrest alone. The Supreme Court in Miranda v. Arizona, 1966, held that warnings are required only when two conditions are met simultaneously. First, the person must be in custody. Second, the officer must be conducting an interrogation. Both prongs must exist at the same time. Custody without interrogation does not trigger Miranda. Neither does interrogation without custody. The Supreme Court reinforced this in Berkemer v. McCarty, 1984, confirming that an arrested person has no right to Miranda warnings absent active questioning. The officer correctly stated he was not questioning the suspect about the crime. Therefore, no Miranda advisement was legally required at that moment. Critically, any statements made by the suspect before interrogation begins are voluntarily given and fully admissible in court. The background information, the suspect disclosed travel route, wife's description, prior park visits was provided without any interrogation pressure. Under the Fifth Amendment, the right against self-incrimination only protects compelled statements. Voluntary disclosures receive no constitutional protection. The Fourth Amendment analysis is equally clear. Under Terry v. Ohio, 1968, an officer may detain a person on reasonable, articulable suspicion of criminal activity. Florida Statute Section 812.015, subsection 3, independently grants authority to detain a shoplifting suspect for a reasonable time. The detention here was supported by both constitutional and statutory authority. The suspect's claim of illegal detention has no legal foundation. Florida does not have a general stop and identify statute. However, once a lawful arrest is made, identification becomes part of the booking process. The absence of identification complicates processing, but does not independently render the arrest unlawful under Florida law.
So like I said, we can do this the easy way and we just sit here and we can have conversation and talk. So once you're done with the statement, just if you can just print it and hand it over to me, and that way I can type everything.
Sam, when you came into the park 5 minutes ago, did you come in with your wife at the same time?
No, she came in, I believe, a little bit before me.
A little bit before you?
Yeah.
What's a little bit like? 20, 30?
Probably somewhere around there.
Do you remember what she was wearing?
Because we took 2 different buses.
You took 2 different buses?
Yeah, because she wanted to get an earlier start than I did.
Okay. Do you remember what she was wearing today?
Gray shirt, and I can't remember what shorts.
The other days, did you guys come in together?
Typically, yeah.
The officer receives a grade of B+. His Miranda analysis was legally precise, delivered calmly and correctly under direct challenge. His statutory basis for the arrest under Florida Section 812 was sound. Evidence coordination with park staff reflected proper protocol. However, the grade falls short of an A because background questioning, travel history, wife's identity, prior visits approached the interrogation threshold. No Miranda advisement was captured on footage prior to that line of questioning. If any statement is later challenged, suppression becomes a viable motion. The suspect receives a grade of C+. He did not physically resist, which prevented escalation and reflects a basic understanding of practical consequences. However, his Miranda argument was legally incorrect, and invoking it aggressively without basis undermined his credibility and legal position. More critically, he spoke extensively before invoking silence. The Fifth Amendment protects those who remain silent, not those who speak first, then stop.
Mike 1151.
Okay, so this is the property from earlier?
Yeah, we don't know. We didn't go through it.
Yeah, okay. Okay.
Can we be more specific on the walker?
Alright, thank you.
Thank you so much.
Yep.
It's going to be in POE in front of the U.S. area around the around the table. It's going to be a bag of 67 items. Copy. Did you say the USF area? Correct. The U.S. The U.S. area in POE. Copy the U.S. area. Charlie, did you copy? Can you do a 61 of that area and see if there's a bag over there? I copy there's a POE or your map area. It sounds like it's a POE rest area because that's the safe area for people to go. 26, yeah, copy 51 next, 51. 152, do you want me to stand by with me? Even though he has a ticket? He cannot come in the park. The park is closed and clear. The gates are open. Vehicle traffic is now going, so he has to stay out there. And Charlie will do it.
The lesson here applies to both sides of the encounter. For law enforcement, accurate Miranda knowledge is not optional. Delivering warnings proactively before any background questioning eliminates suppression risk entirely and costs nothing procedurally. For civilians, Miranda does not function as a pause button on a detention. Silence must be invoked immediately and maintained consistently to be effective. Knowing a right exists is not the same as knowing how to exercise it. Misapplied constitutional knowledge can be more damaging than no knowledge at all. Let us know if there is an interaction or legal topic you would like us to cover in the comments below. Thank you for watching, and do not forget to subscribe to our channel for more content on police and court interactions.